Hello, everyone. Welcome to the Clarkslegal Immigration Insight podcast. I'm Ruth, your host today, and joining me is my colleague Monica. Today, we are unpacking the major changes to the UK immigration rules published by the Home Office on the 1st of July 2025, a key part of what the government calls a complete immigration reset.
That's right, Ruth. These changes affect employers, visa holders, and particularly those on the skilled worker and global business mobility routes. So, let's walk through what's new, what it means, and how organizations can get ahead of the curve.
Let's start with the skilled worker route, which has seen major changes from 22nd of July 2025.
What's the biggest shift? Applicant must now be sponsored in job at RQF level 6 or higher. That's equivalent to graduate level jobs. This reverses the previous 2020 rule that allowed sponsorship at level 3, like many technician or administrative roles.
So, for example, a retail floor manager or care home assistant previously eligible under level 3 would now no longer qualify unless their role is specifically listed on the updated immigration salary list or temporarily shortage list.
On top of that, the salary threshold for most roles has increased from 37,800 to 41,700. Occupation specific rates have also been updated using the 2024 annual survey of hours and earnings.
That means, say, an IT project coordinator being offered £40,000 may fall short of the new requirement, even if they qualified before.
It's not just skilled workers being affected. The global business mobility, senior or specialist worker route, now has a salary threshold of 52,500, up from 48,500.
And while transitional protections apply for people already in the UK or with pending applications, there are no salary level exemptions. Employers cannot rely on an old pay scale.
Let's take an example. A mechanical engineer, sponsored last year at 49,000, might be safe if they're renewing their visa. But hiring a new candidate for the same role would now require meeting the 52,500 threshold if it's under the Global Business Mobility Senior Specialist Worker route.
Exactly. And eligibility will now depend on heavily on whether the job appears on the immigration salary list or the new temporary shortage list, both of which are scheduled to be phased out by the end of 2026.
So, these are interim tools. If a warehouse supervisor role is currently listed on the immigration salary list, that window won't last forever. Planning ahead is crucial.
A big headline from this update is the impact on the adult social care recruitment.
From the 22nd of July 2025, new overseas applications for care worker or senior care worker roles under the skilled worker route are closed.
But they still apart for those already in the UK. In-country switching is permitted until July 2028, as long as the workers have already been with their sponsor for at least 3 months.
For instance, a student visa holder working part time as a care assistant could still switch into the skilled worker route if they meet the timeline and sponsorship requirements.
Another restriction, dependence. New care workers sponsored under the immigration salary list or the temporary shortage list cannot bring family unless they're already on the route or have UK-born children or sole parental responsibility.
That's a significant change and could affect an employer's ability to attract candidates from overseas in this sector.
Let's move to few additional changes outside of work visas.
So, the Afghan Relocations and Assistance Policy, or ARAP, has now closed to new principal applicants as of 1st July 2025. But existing cases and family applications will still be processed.
Meanwhile, neonatal care leave, a new statutory entitlement from April 2025, is now a valid reason for sponsored workers to be away from work without affecting visa compliance.
So, if a sponsored employee is a premature baby requiring extended hospital care, their absence during neonatal leave won't trigger compliance issues for the employer or visa holder.
And a big shift for EU settlement scheme holders. From 16 July, pre-settled status holders can qualify for settled status if they have lived in the UK for just 30 out of the last 60 months, even with longer absences.
Let's say someone spent 2 years in the UK, then left for a year to care for a parent abroad. Under previous rules, they'd be ineligible to apply for settled status, but now they may qualify either automatically or via a fresh application.
So, where does this leave employers and workers?
Employers need to audit their current workforce to identify anyone affected by salary or role restrictions. They should also review upcoming sponsorships and adjust recruitment pipelines.
For example, a company planning to bring in 10 new warehouse operators from overseas may now find that those roles are no longer eligible unless they appear on the temporary shortage list. And even then, the ability to sponsor dependents is restricted.
And for individuals, especially in healthcare or logistics, it's time to think about switching routes, checking ILR eligibility, and staying ahead of deadlines like the 2028 care worker cutoff.
At Clarkslegal LLP, we're supporting clients by offering workforce audits, compliance training, and visa strategy, especially for sectors like care, construction, and healthcare where impact is high.
We also help individuals assess their options, whether it's switching into a different visa route, bringing over family, or planning for indefinite leave to remain.
These are significant, complex changes. Employers and individuals alike need to act early to stay compliant and avoid disruptions.
Thanks everyone for listening. For more tailored advice, visit clarkslegal.com or please drop an email to our business immigration team.
We will be back with more updates soon. Until then, stay informed and stay compliant.